realized I left out a brief thing where I told both candidates that they would have 3 minutes each to make an opening statement for tonight. I apologize for forgetting that part. Thank you.
No problem. We will
start with that.
Yes, let's go ahead and start with that. Madam DA, if you'll begin.
Thank you. Good evening, everybody. I appreciate the opportunity to be here. As Emily has said, this is my third run for district attorney here in Wake County, having first become district attorney in January of 2015. And this is actually the third election cycle that I have come to this very auditorium to talk to people. And so I appreciate Campbell Law School always hosting us, because it is important for us to have this opportunity to talk to people about our vision for our criminal justice system here in Wake County. As many of you know, over the last 7 years, Wake County has been a leading place in the country for people to move to. And that is largely driven by our high quality of life. And part of that quality of life that we have all enjoyed really has to do with our ability to live safely in our communities, to go about our daily activities in a safe community, but also to be in a community, and one that I'm so proud of, because we believe in trying to lift each other up and help each other. And so as your district attorney, I have worked hard, one, to make sure that violent criminals are detained and that we address that in a way that cuts down on their ability to do harm to our community. But we have also worked diligently to try to improve the fairness of the system. And that looks like a number of different things. And I look forward to the opportunity to talk with you about that tonight, but just to talk briefly about 3 of them. One, we have expanded our deferral programs. Wake County has long had deferral programs for low-level, nonviolent offenses, and we have expanded those and continue to try and use that as an opportunity to give people a second chance. 2, I have worked diligently with a broad range of community collaboratives, agencies, to try to help people re-enter into the community as they exit the criminal justice system so they can live stable, successful lives. And I think that's very important for us to be able to cut down on recidivism in our community and to give people that opportunity. And then 3, this past year I have chaired a stakeholder group to revise and reform our pretrial release policies, and I look forward to talking a little bit more about that this evening. But a commitment that we are not detaining people in custody awaiting trial who do not need to be there. We understand the harm that is created by that, and so I've been proud to lead this collaborative that is rolling out new reforms in this area over the next couple of months.
Thank you, Ms. Freeman. Mr. Chapman.
Thank you, and I understand we can remove our masks while we're speaking. In May of 2020, my wife and I, Catherine, went to downtown Raleigh to protest the killing of George Floyd. George Floyd, of course, had been killed in Minnesota by Derek Chauvin. And joined that day in May of 2020 were citizens from throughout Wake County and Raleigh who were concerned not just about the killing of George Floyd, but also about the violence that has been wrought on members of our community by the police and other law enforcement. In particular, the names that were being chanted that day were Kyron Hinton, were the young woman who had been flipped on her back by a Rollsville student resource officer in Rollsville High School, about people who have been shot and killed by police. That was the concern. And my wife and I protested with the other folks down in downtown Raleigh, and my wife and I went home, and I returned later that evening as a legal observer to ensure that both the protesters and the police behaved appropriately that evening. And the protesters were mostly, for the most part, protesting peacefully. But over time, the police grew frustrated, and there were some little outbreaks of misconduct by the protesters. But the police pushed the protesters street by street, down Martin Street, down Wilmington Street. And as the protesters were pushed and kettled down the streets, windows were broken. The next morning, when you woke up in Wake County, you didn't hear about Kyron Hinton. You didn't hear about the people who had been shot or physically abused by the police. You heard about the violence and the property damage. And of course, no one should tolerate property damage when it comes to personal property or businesses. But the fact of the matter is that there are large parts of our community that are concerned about police violence. They are concerned about police misconduct. That is represented in addition by the case of Omar Abdullah, a Raleigh police detective who for months and years arrested people, members of our own community, on fake drug charges. That came to attention in January of 2020. Joel Brown reported on that on ABC News in September of 2020. And yet 2 years later, we don't have a clear understanding of how 15 of our fellow citizens were in prison for a combined total of 2.5 years on fake charges. It is clear that we need to do more in Wake County about this. And as your next Wake County District Attorney, I will do 4 things. The first is that I will end the death penalty in Wake County. Currently, the Wake County District Attorney seeks the death penalty more frequently than any other DA in North Carolina, and that's not me saying that. That's the Center for Death Penalty Litigation. Second, I will not prosecute the adult use quantity of marijuana.
Mr. Chetson, your time is up. Thank you.
Thank you.
We will proceed with the questions. Ms. Freeman, please answer this question first. What is one thing that sets you apart from your opponent, and why is it important?
I think the thing that sets me apart from Mr. Chetson is the experience that I bring to the job, that I have been in this role for the last 7 years, and prior to that served as the elected clerk for 8 years, and leading an office within the criminal justice system that shapes the policies, that does the things we've talked about, keeps this community safe, but also makes sure that the criminal justice system is fair, is a difficult and complicated job, and I have the experience to do that, and he doesn't.
Mr. Chetson, your response?
What sets me apart is my vision for what Wake County can be. I have a vision for Wake County that ends the death penalty, that does not prosecute the adult use quantity of marijuana, that builds an inclusive Wake County District Attorney's Office. The leadership of the Wake County District Attorney's Office in a county that is 20 to 25% African American and 10% Hispanic is almost exclusively white. And I will focus on ending the pay-for-play system of justice that we have in Wake County. So it is a difference of vision.
Thank you. For the edification of our participants and viewers, for a little context, for a few of the questions, I will provide a brief background on the topic before moving forward with the question. The first topic we're going to discuss is marijuana. In a memo released in 2019, the North Carolina State Bureau of Investigation stated that there's a variety of industrial hemp that, quote, looks like marijuana and grows buds just like marijuana. CBD is extracted from the buds. This type looks just like marijuana, including the leaves and buds, and it smells just the same as marijuana. In fact, there is no way for an individual to tell the difference by looking at the plant. One would need a chemical analysis to tell the difference. The same memo states that there is no field test that distinguishes the difference. Lastly, the memo states that the North Carolina State Crime Lab does not conduct testing to differentiate between hemp and marijuana. Criminal analysis of a substance alleged to be marijuana is not done for misdemeanor marijuana cases, and is often not done for felony marijuana cases either. Do you see any ethical dilemma with continuing to prosecute marijuana charges in which no chemical analysis has been performed? Mr. Chetson?
Thank you for that question. I do see an ethical dilemma in continuing to prosecute cases, which, as you clearly, and that report clearly indicates, require a chemical analysis to determine whether there are high enough levels of THC. We continue to prosecute those cases in Wake County. We have a no-drop policy in Wake County, including the prosecution of felony levels of marijuana. Let me be clear, not only is the issue CBD, but also adult use quantities of marijuana. As your next Wake County District Attorney, I will not prosecute adult use quantities of marijuana in Wake County.
So I think there are a number of things that are really important to get on the record straight about marijuana and the use of marijuana and the enforcement of that in this county. First of all, we have increasingly not arrested people for the use of marijuana when you're talking about, just simple use possession amounts. And it has shifted largely to a cite versus arrest policy. Secondly, our county for decades has had deferral programs, not only at the misdemeanor level, but also at the felony level so that we can make sure that people who are using substances are getting connected with treatment so that they don't fall into a habit of addiction or into other patterns that might lead to criminality. That was a memo that was written when the debate about smokable hemp and making smokable hemp legal at the legislature was going on. Since that time, the ability to test marijuana and the substances has improved both locally and nationally. This is an issue for the legislature. At the end of the day, I do not think it is appropriate for someone who holds an oath to uphold the law to say that I am not going to enforce a law that is on the books. Having said that, we have pushed to deprioritize the criminalization of marijuana, and when it is charged, we try to give people an opportunity to find other ways to get that off of their record by going through deferrals.
Let me ask a follow-up question, and I'll allow Mr. Chetson to answer this first. In what ways do you plan to address the disproportionate application or prosecution of people of color for alleged marijuana crimes?
Let me respond first to something that Ms. Freeman said, which is that we have deferral programs in Wake County for marijuana. The problem is that we do have those deferral programs, but they're exceptionally expensive. They don't assist people that are on the poorer end of the economic spectrum. So that's one issue. And the second part of that is that they require the defendant to plead guilty. So they require a guilty plea, and then after you complete certain steps, you can get the case eliminated. The problem is that if you're poor, it becomes very difficult to comply with the deferral program. Let me get to the second point of your question, which is that by not prosecuting the adult use quantities of marijuana, you are immediately addressing one of the racial inequities in our system. The problem is that white folks typically economically are better off, and when they smoke marijuana, they can smoke it in their homes. They can smoke it in places where the police aren't free to travel. People that are on the poorer end of the spectrum, which unfortunately affect our black and brown neighbors most disproportionately, smoke marijuana in their car or have it in their car. And so when police pull the car over, they can then have the pretext to search the car.
Mr. Chetson, your time is up.
Thank you.
Ms. Freeman?
Our referral programs are run through Southlight, and they regularly, when someone is indigent, waive those fees. And so to say that those programs are not available to people based on indigency or based on ability to pay is simply not true. In terms of, how do we address this, I think this is part of a larger issue where we have to really think about what is feeding people into the criminal justice system and try to ensure that we are doing that in a fair way and that we aren't continuing to disproportionately impact any particular part of our community. Some of that has to do with policing patterns. Some of it has to do with how do we stand up additional resources in various parts of our communities. That is a complex question that 60 seconds is not enough to answer in. But I think what's important is, that we are not prioritizing the prosecution of marijuana, but because it is the law, we will continue to enforce the law.
In both of your responses, you mentioned race and race equity. There's no doubt that race plays a role in many aspects of our society, including but not limited to the criminal justice system. The question is, do you believe racial inequity is a problem in the Wake County criminal justice system? What changes can the Wake County District Attorney's Office, if any, make to combat this inequity? Ms. Freeman?
I think there is no question that if you walk into a second floor courtroom down at the Justice Center, that what you will see is that there is a disproportionate number of people from the communities of color in our county that end up in the court system. What all the different factors are that lead to that, I think, are complex. What our role is in the criminal justice system is to ensure that people who do end up in the criminal justice system are treated fairly. And so there are a number of different things that we try to do to ensure that we mitigate any of those disproportionate impacts. For an example, coming in as district attorney, I introduced a pre-filing diversion program for offenses for 16 and 17-year-old for offenses that were happening at school. That was a partnership with Alliance to divert away from the criminal justice system altogether offenses that happened at school and to connect those individuals with resources. I think those types of programs are important to start to divert away things that really are behavioral health issues other concerns from the criminal justice system. But I think we have to all be honest about the fact that there are a lot of factors, a lot of inequities in many different systems, including the health system, the economic system, the education system, that find their way funneled into the criminal justice system. And the criminal justice system alone cannot fix those.
Well, Ms. Freeman, allow me to ask a follow-up question. You mentioned that you want to ensure that those who end up in the system are treated fairly. Isn't it inherently unfair for people of color to be overly represented in our criminal justice system?
I think it depends on the reasons that people are ending up in the criminal justice system. Our role within the criminal justice system, what I have control over, what we have control over within the criminal justice system, is to ensure that the system is fair and that it does not compound what might be pre-existing inequities in society or in what ends people up there. And so things such as looking at fines and fees, things such as looking at the pretrial release system, there are areas that need to be improved that I have worked diligently over the last 7 years to try and make improvements in.
Mr. Jackson?
Yes, in 2002, Ms. Freeman wrote in a report that there is no disparate treatment of offenders based on race in the criminal justice system. And what I hear is something somewhat different this evening. That's what she wrote in 2002 in a report. I believe that there is disparate treatment based on race in the criminal justice system, and I think we need to solve it. This problem extends to the Wake County District Attorney's Office. In a opinion handed down by the North Carolina Supreme Court just a week ago, in State v. Clegg, the North Carolina Supreme Court held that two, or at least one, assistant district attorney in the Wake County District Attorney's Office had struck African American potential jurors on the basis of race. That is inherent in the system. For 40 years, we have had the rule in the United States that you cannot strike a potential juror solely on the basis of race. And yet the Wake County District Attorney's Office continues to do that practice. In 40 years, the North Carolina Supreme Court has yet to overturn a conviction on the basis of this rule called Batson. And yet Wake County is the first time that should happen. One of the steps that we can address is proper culture within the Wake County District Attorney's Office that makes people aware of the issues related to race and also the issues related to racial inequities and the issues related to Batson and the proper implementation of that in our court system.
Ms. Santi, I think I get 30 seconds to respond.
Correct. Go ahead.
I think this is a great example right here, folks. Mr. Chetson is citing from 2002 a 20-year-old report that was issued that I was staff for the North Carolina sentencing on, talking about findings that were made from that report. I was one of a team, and I might say 20 years ago I was a lot younger, and a junior member of a team that did that study. Folks, you need candor from your district attorney. You need somebody who is going to be honest with you and tell you the facts, good or bad, but that is required in this role. I think that's really important.
Mr. Chetson, let me ask you a follow-up question.
Could I simply respond to that one issue by saying the case in State v. Clegg was from 2016 when my opponent was the elected district attorney of this county, in which one of her prosecutors struck somebody and was unable to provide what's called a race-neutral reason for striking that African American potential jury. And the Supreme Court, for the first time in 40 years, ruled that that was inappropriate and that conviction should be overturned. So we overturned a conviction in this county because of an inability to comply with the basic rule that all people should be treated equally.
Folks, let me go ahead and say briefly, I'm going to take the slight liberty of allowing brief extensions beyond the 60 and 30-second time. Again, I hope you allow me to do so. We have some important questions and topics to discuss here. So as long as you don't abuse it, we can continue, but just want to put that out there. Mr. Chetson, a follow-up question for you. You cited the study, you cited the Supreme Court's opinion. What do you say to folks who say, well, it's convenient looking on the outside in to make these criticisms and make these statements and proclamations about what is wrong with the current district attorney's office? How do you respond to people who say it is not going to be that easy for you to hop in and change a culture that is so deeply rooted in our country and not limited to the current district attorney's office?
And I certainly agree that these issues are deeply rooted in the country and these are not easily resolvable issues. But compliance with certain basic fundamental constitutional rights, such as that all people can serve on a jury regardless of race, is a fundamental principle and should be easily implemented. And so I would require that the ADAs take the kind of training that ensures they can comply with the law. So that's number one. Number two is that we, as I mentioned in one of my earlier statements, we have a Wake County District Attorney's Office that fails to adequately represent the diversity and inclusivity of Wake County. And so what I would do was increase and look for those people that are well qualified, who are people of color, to join the office, to recruit those people and retain those people. And then the last point is that in the past 3 years, the Wake County District Attorney's Office has lost more than 20 assistant district attorneys. Now, as everyone knows, the Wake County District Attorney's Office has 43 prosecutors and an elected DA. When you lose 40% of the DA's office, you have a problem with people understanding how to properly prosecute cases. And I say that with all due respect to the prosecutors, many of whom I consider my friends, who are excellent prosecutors, but we need to fix the culture in the Wake County DA's office.
Ms. Freeman, a response?
Sure. I think exactly what Mr. Chetson has said in terms of bringing in training about implicit bias training is incredibly important. And that's why in 2020, spending my own money, I did bring in, for a period of about 12 weeks, a trained facilitator to work within our office to have trainings on implicit bias, and specifically how we identify and try and root out implicit bias within the system. I've also partnered with conference of district attorneys in trying to bring additional training to prosecutors, not only here but across the state, on those types of topics. And I think that's really important. Secondly, almost half of my hires into the Wake County District Attorney's Office in the last 7 years have been from various communities of color within our county. In fact, 2 of you are here this evening. It is important to me, I absolutely agree, that our office needs to be reflective of our community, and that is why I have made that a priority, and I will continue to do that. Fortunately, people find better opportunities and move on to other opportunities and use our office as a springboard, and I commend them for doing that. I'm excited when that happens, and we continue to try and backfill that with people who are reflective of our community, because that is important.
Let me ask a final question on the topic of racial equity before we move on. You have both made statements that show or represent your support of establishing or achieving racial equity within our system. If you are truly indeed committed to racial equity, what are you doing, or would you support a person of color to run for district attorney in Wake County? And if so, how do you propose that happen? Mr. Chetson?
Yes, in fact, I have a wonderful life. I'm very privileged. When I was considering running for Wake County District Attorney, one of the things that I did was reach out to folks, including particularly people of color, about running for office. Unfortunately, I was unable to recruit that person, and so it's fallen upon me. I love my life. I love being a defense attorney. I will be proud to be your next Wake County District Attorney's Office, but I'm certainly eager for there to be people of color, and one of the ways that I can help contribute to that is by recruiting folks into the upper echelons of the Wake County DA's office who are people of color, African American, Hispanic, Asian American folks, to come into that office so that they can develop the experience and become the next Wake County District Attorney.
Ms. Freeman?
Absolutely, I support that and would love to see that one day. And my commitment to this issue predates long me being district attorney. And as clerk of court here in Wake County, I set up internship programs with our historically black colleges here in town, specifically to try and give individuals an opportunity to come and work within the criminal justice system. We hired them into the clerk's office. We encouraged them to go on with their education. Some of them have gone to law school. One of them is sitting for the bar in the next 2 weeks. I think what we have to do is continue to encourage and to support and to cultivate that next generation of leadership, and 100% I support that.
I want to move on to talk about victims and victims' rights. As you both know, victims are a part of our criminal justice system, and the safety, well-being of victims must always be considered. The first question is, how can victims of crimes be better supported in the criminal justice system? Ms. Freeman?
I think a big part of that has to do with our ability to adequately support and address the needs that they have and to move cases quickly through the system. And largely that is a resource-driven issue. Here in Wake County, we actually have one of the quickest and highest rates of disposition in terms of time frame, and yet we operate at about 30 district attorneys or assistant DAs less than Mecklenburg that has a similar caseload than we do. I think one of the things we have to do is continue to make sure that we are making the contacts that we make. But, we have a good relationship with the victims in this community that we have served, because I am proud to lead a team of 42 individuals who take that responsibility and their role to finding justice for victims very seriously.
Mr. Chetson?
I have some familiarity with this because as a defense attorney, not only do I represent folks that are defendants in cases, but I've also had the occasion to represent people who are victims who need representation with the district attorney's office. And so I take very seriously that issue. Ms. Freeman talks about moving cases rapidly through the system, and yet the problem is, in part, this is driven by a lack of priorities, is that we have a very reactive DA's office. DA's office that only in 2020 decides to implement racial bias training, far too late in the game. And one of the problems is that we have a court system that's simply overwhelmed. Part of that problem is resource-driven. We only have 43 DAs. I believe the next Wake County District Attorney needs to use the very loud bullhorn that the DA's office has to push for more resources, whether it's from the legislature or whether it's from the county, so that we can increase the number of DAs. The second issue is that by focusing on very minor crimes like misdemeanor or adult use quantity of marijuanas, we are not devoting the resources to handling the roughly 100 pending murder trials in Wake County. One final point about that. In the last 3 years, the Wake County District Attorney's Office has prosecuted, or when I say prosecuted, brought to trial roughly 25 murders. Unfortunately, almost 10 of them have not resulted in a conviction for first-degree murder, which means that there are folks out there who were accused by the Wake County DA's office of first-degree murder, of killing somebody, and they were not convicted with a jury. That is an appalling statistic that leaves us all unsafe, whether because the wrong person was prosecuted or the right person was prosecuted and a first-degree murder conviction was not achieved.
Mr. Chetson, allow me to ask a follow-up question. You described it as being appalling that those number of folks were not convicted of those crimes for which they were charged and prosecuted. As an attorney, is it or is it not true that when a case goes to a jury trial, it is indeed up to the members of that jury as to whether they decide if the state has met their burden or not? And if that is in fact true, how do you account for your statement then that appears to put the onus on the district attorney's office for the decision of the 12 men and women in a jury box?
Sure. Let me focus on that. The federal court system, where I also practice, has a 95% conviction rate. A 95% conviction rate. And that is even higher in some cases when you reach trials. The Wake County District Attorney, when it brings a case to trial, it's true that the jury ultimately makes a decision. But when the Wake County District Attorney, as the representative of the state, says that this human being killed somebody and deserves to be in prison for the rest of their lives, then the Wake County District Attorneys better be confident about that, have done the investigation, or had the Raleigh Police Department or Cary Police Department do the adequate investigation and prove that case to a jury. The fact that those cases end up not being convictions means one of two things is true. Either the person you put on trial did not do the crime, in which case they waited 2, 3, 4 years in jail being innocent people, and that's appalling, or they committed the crime and you were unable to establish that to a jury of your peers, in which case the guilty person has gone free. Now, I am a firm believer in our jury system. I am a criminal defense attorney. I think that's the backbone of our system. But from the state's perspective and for the citizens of Wake County, one of those two things is true, And either way, it's an appalling result.
Finally, Mr. Chetson, you don't expect to have a 100% conviction rate, do you?
No, I do not. But I think it's awfully problematic to have the kind of conviction rate we have in Wake County at the current time.
Ms. Freeman?
I think first, anybody who knows anything about the criminal justice system, to try and compare the conviction rate of the federal system to the state system, where in the federal system you get to pick and choose what cases you move forward with, I don't think that is an accurate or a good comparison. Our office commits to not take to trial, not to charge anyone with homicide who we do not believe that there is sufficient evidence beyond a reasonable doubt to convict them. And we do not take to trial cases that we do not believe that there is sufficient evidence beyond a reasonable doubt to convict them. Lots of things happen in a trial setting. Sometimes witnesses are not cooperative. There may be reasons why cases ultimately a jury makes a different decision. But to your point, Ms. Asante, the role of the prosecutor is to move forward in those cases, to put forth the state's evidence, and to leave it in the hands of the jury. And we are not supposed to be counting convictions like some notch on a belt. His statistics also are not accurate. What I would say is, twice already tonight, we have heard about the last 3 years, and we all know that we are 2 years into a pandemic. So the statistic about people leaving our office, we all know that we have just gone through in this country what has been deemed the Great Resignation. The statistic about people coming out and us going to trial in a number of cases. In 2021, which is the time frame which I have the most recent data for, we had a 70% conviction rate on murders. But again, that is not a number that I think prosecutors need to be focused on. What we need to be focused on is ensuring that we are not moving forward in cases where we do not have good, solid evidence to prove beyond a reasonable doubt, and then leaving it in the hands of the jury to make the right decision.
I want to talk a little bit about a group of victims who are often unheard and even sometimes harmed in the course of proceedings in the criminal justice system. And those are victims of crimes who are immigrants. What have you done or will you do to establish the DA's office as a safe space for immigrant victims of crimes? Mr. Chetson?
So I have also represented immigrants who are victims of crimes as a defense attorney. As the next district attorney, there is something called the U visa, and the U visa allows someone who is a victim of the crime but may not be here legally to remain in the United States pending the prosecution of that case. I will be very aggressive in granting the U visa to allow folks who are victims of crimes to remain in the United States and to remain available for prosecution, because that protects everybody, whether somebody is here, was born and raised here, or has legal status or does not have legal status. The U visa ensures that the Wake County District Attorney's Office can prosecute the people who abused them, that did violence to them, that committed criminal acts. So that would be a key way in which I do that. The second issue is that I would look to implement and extend and expand the universe of deferred prosecution. We have deferred prosecutions in Wake County, and the issue with deferred prosecution, if you are not in the United States legally, if you are not a documented resident of Wake County, is that if you enter into a written deferred prosecution agreement, that can be later taken by ICE and you can be deported. The problem with that is that many of these folks have been here for longer than I've been in North Carolina, 20 years, 30 years. They call this their home. They have families here. They have jobs here. And so when they come into the Wake County District Attorneys and confront the Wake County District Attorney and say, I need a deferral program that does not leave me to be removed from the country, the Wake County District Attorney's Office sometimes will not honor that request. And so you end up harming the defendant, but also the whole family and the support system that person, that defendant, was working to support. So I would use deferral programs to expand the range in which people who are not here with legal status are able to remain in this country, and not use the Wake County District Attorney's Office as a method to achieve deportations.
Ms. Freeman?
Focusing on victims, I think there are a number of things that are important that we do. One is to make sure that we have people on staff, victim service coordinators, advocates, who can work with victims who speak Spanish. And that is something we do have and something that's important. So, and as we outreach and try and provide support to those victims going through the system. Secondly, as Mr. Chetson has indicated, certainly, taking a position on U visas that is favorable to victims as they are cooperating with investigation and prosecution, and we do that. And in fact, those now funnel through me specifically to look at and to make sure that we are being, as gracious as we can be under the confines of what the federal law allows. And then thirdly, I'm proud to have helped stand up with the North Carolina Victim Assistance Network, a homicide support group, 7 years in this community, and they have now been able to transition that to also have a Spanish-speaking it's a homicide support group. And I think those are the kinds of programs, making sure that we have the support for victims that are culturally sensitive and that are bilingual, is part of providing that support to victims who find themselves entangled in the criminal justice system.
Mr. Chetson, briefly.
If I could respond very briefly, this is very personal to me. My sister is married to a woman who is naturalized. She's of Mexican national origin, but she has been naturalized as a United States citizen. When Donald Trump was elected president, I got this frantic call a couple of days later about what he might do to try to denaturalize people who had been naturalized as United States citizens. My nephew, who they had together, Ociel, only speaks Spanish. So this is very personal. Somebody's immigration status should be something that we really think about carefully when we prosecute as a local prosecutor's office, and that's why it's so important to me.
Ms. Freeman, would you commit to creating an office-wide policy requiring assistant district attorneys to consider the avoidance and mitigation of immigration consequences in their plea negotiation practices, sentencing recommendations, and post-conviction practices? Why or why not?
I think it's very important that all of the assistant district attorneys be aware of all of the collateral consequences that come with a conviction. And so, yes, while that cannot always be the only factor or the primary factor that gets taken into consideration, I do think that it is important that that is part of what is taken into consideration in making these determinations.
Mr. Chetson?
I recently had a client who had been prosecuted by the Wake County District Attorney's Office, was a naturalized U.S. citizen. After that prosecution was done, the federal government took the case and proceeded with denaturalization process to have that person removed from the country. This is a man who had committed a serious crime, but had also served in the United States Army and had obtained his citizenship. So if there has been careful consideration of immigration status when considering plea offers in Wake County, I haven't really seen it, and I've been practicing in these courts for at least as long as my opponent has been the elected district attorney. I think those things need to be looked at again. I think we need to be careful about how we treat folks. And when people say, well, these people are here illegally, keep in mind that one of my clients, not in this county, recently prosecuted and subject to deportation, was here in the United States from the age of 2. And so he was a DACA person when he came into the system, ended up losing that status because of the result that he got. Not in this county, not Ms. Freeman's issue, but these issues strike to the heart of a lot of our good law-abiding neighbors, their families, and the people that are hurt by collateral consequences, which are the children and the wives and the nephews and the friends of people who ultimately are deported because we aren't being careful enough about that in Wake County.
I want to transition to talking a little bit about Raise the Age, the school to prison pipelines, SROs, and those related subject matters. Prior to December 1st, 2019, in North Carolina, 16 and 17-year-olds were charged in adult court rather than juvenile court. In 2017, the North Carolina General Assembly passed a law to, quote, raise the age. Under this law, beginning December 1st, 2019, 16 and 17-year-olds were no longer prosecuted in adult court except in cases involving Class A through G felonies. It was mandatory that these cases be transferred to adult superior court. In 2021, the General Assembly changed this law and made it discretionary for district attorneys to transfer D through G felonies to adult superior court. What criteria will you use to determine when to request discretionary transfer to adult court? Mr. Chetson?
One of my and our prior law was absolutely horrible, and I practiced in the adult criminal cases with kids that were 16, 17, and 18 years old brought into adult court by default because that's where they were considered adults. I would take into consideration the kind of crime that had been committed or alleged to have been committed, what the victims were saying about that, about the person's developmental circumstances in deciding whether to bring that case into adult court. I will say that my opponent came around to supporting the raise the age law, but it took some effort. And she has statistically used the law to bring people who are very young. We're talking about, 15, 16, 17-year-old kids into adult courts. We know, and the science is very clear, including the science before the Supreme Court of the United States, which is a conservative Supreme Court, that folks don't have the right developmental maturity, even up until later ages, but certainly as late as 18. So I would focus on keeping these cases in the juvenile courts. And the reason why this is important for those of us who do not practice in the criminal courts or the juvenile courts is because there are a vastly larger amount of resources available to potential offenders in the juvenile courts. And so we can start treating the issue at an earlier age rather than not treating it, throwing them into adult prisons and having them be problems later on. It makes all of us safer.
Ms. Freeman?
Certainly, I supported and, in fact, encouraged and won the support of the Conference of DAs for that law change in 2021 to allow people who are 16 and 17-year-olds to remain in juvenile court at the discretion of the prosecutor, because I felt like that was important and that largely children who are under the age of 18 should be handled through the juvenile court system because of the rehabilitative impact that the juvenile system can have. But when there are serious public safety issues and violent offenses, prosecutors need the ability to keep their community safe, and that means that there are times when juveniles, people under the age of 18, will need to go to adult court and be prosecuted in adult court. I think my record on this issue is pretty clear. 25 years ago, I helped set up the teen court program here in Wake County. 7 years ago, when I came into office, I helped set up the school pre-filing diversion program for school-based offenses. Low-level, nonviolent offenses need to be handled outside of the criminal justice system for juveniles. Offenses that can be adequately handled within the juvenile system need to be handled there, but when it is a threat to public safety, I have a responsibility to protect this community.
Mr. Chetson?
One issue with that is that I think a lot of states have it better than North Carolina, and this would require a legislative change, which is that it shouldn't simply be up to the district attorney to make that decision. That request should be submitted to a judge, a neutral decision maker, who can say, yes, this is the sort of case that ought to be brought into adult court or not. I think that would be a fairer way of achieving what we need to achieve, because the problem with Ms. Freeman's statement that there are issues of real public safety is that public safety becomes then a catch-all phrase that is used to bring every case that you want to bring into the adult courts, where you can prosecute the people more harshly, and fail to provide these very young offenders with the resources they need to be able to be reintegrated into society and not be future issues of safety concerns in our society.
Moving on to the next topic, serving as district attorney is about accountability. Accountability to the people you serve, to the people of Wake County. It is no surprise that there are a lot of discussions going on about what that accountability looks like for the district attorney's office, for law enforcement. In 2020, the Wake County District Attorney's Office dismissed charges against 15 defendants who were wrongfully charged with trafficking heroin by former RPD officer Omar Abdullah. Mr. Abdullah has been terminated from RPD for his actions surrounding this case, and the city of Raleigh negotiated a $2 million settlement in a federal civil rights lawsuit stemming from these cases. How do you propose that your office, Ms. Freeman, handle the rapidly growing movement to hold law enforcement officers accountable?
First, let me say that it is a prosecutor's nightmare for someone to be wrongfully convicted. None of us go into our jobs wanting to see that happen. As to the matter involving Officer Abdullah, that matter, as my opponent knows, remains under investigation, so my ability to talk about that is limited. I have consistently, as recently as last week, taken the opportunity to hold law enforcement accountable when they broke the law. Last week I secured a conviction against a law enforcement officer who had spent 6 years lying to training and standards about training that he was providing to the elected sheriff and deputy sheriff in Granville County. Why is that important? It's important, one, because we expect our law enforcement officers to be trained and to be proficient, and that is part of what we need from them. But more importantly, or equally as importantly, we expect them to tell the truth. And when you give somebody the authority to take out arrest warrants, to search people's homes, that is an incredibly important standard to hold them accountable to. And again, when the evidence has supported it, I have been willing to move forward in those cases. But where the evidence is not there, I cannot move forward against a law enforcement officer any more than I should move forward against anybody else in this community in seeking a conviction when there is not sufficient evidence to do so.
Mr. Chetson, before I move on to you, Ms. Freeman, you raised the conviction you secured last week against the sheriff deputy from Granville County. Is there anything you would do differently in handling that matter?
Yeah, certainly. First of all, let me say that part of that case also remains pending, and so I need to be careful about what I say. But obviously, I know as part of that, there were motions filed in that case. It has been reported, and I would say that what is in those motions is not accurate, but there are parts of it in terms of an exchange that I made with the DA there, and while I think we can argue about whether that was ethically appropriate, some of the language that I used was not appropriate given the position that I hold, and I publicly apologize for that. But when we have law enforcement officers who are abusing the system, and we have people who are calling out the prosecutors, which happens across the country, when prosecutors dare to take on law enforcement officers, they always get called out as corrupt. And when that happens, and unfortunately that's what you saw, I have a knee-jerk reaction to it. And unfortunately that's what came out as part of that motion.
Mr. Chetson?
And certainly I appreciate that I think that folks, and that's one of the nice things about my opponent, I believe that, when something happens that she apologizes for it, as I do, because we are all human beings. So I think that's heartfelt. One of the problems, though, is what I think that Granville County case showed was that what the prosecutor did in Granville County was send the case out of county to have a neutral, non-conflicted prosecutor prosecute the case. Consequently, the result was a guilty result. I have committed, as the Wake County District Attorney, where there are significant accusations of police abuse or police violence or police misconduct, to have an independent prosecutor, not just the SBI investigator, but an independent prosecutor, just as was done in that case, prosecute those police officers. So, for example, with Omar Abdullah, to have that prosecution, if there is one to have that happen by a prosecutor's office, either out of county or by the state attorney general. And if I could just have one more moment on that issue. When Derek Chauvin was prosecuted in Minnesota for the killing of George Floyd, that was not done by the Hennepin County DA's office, that was done by the Attorney General's office. And that's because we all know, and those of us who work in the system know this more clearly than others, is that you become friends with, even if you're a defense attorney, you become friends with, and you come to know the police officers. So number one is you want to not have any conflict of interest, either real or perceived, because you don't just represent, as the district attorney, the police department or the DA's office. You represent the people of Wake County. And they have you have an obligation to them, not just to do a fair prosecution, but to be perceived as being fair. And when my wife and I were down in May of 2020 in downtown Raleigh, hearing people complain about the way in which the Wake County District Attorney has failed to prosecute police who are perceived to have been abusive or have committed acts of police brutality, what people were talking about was the perceived idea that the Wake County DA's office is not doing what it should do. The way to cure that problem is to send those cases to the Attorney General's office or send them to another county. And as the Wake County District Attorney, if there's prosecutors in other counties, say Johnston County or Durham County, who believe that they have police officers that have engaged in misconduct, I would be happy as the Wake County District Attorney's Office, because I wouldn't know those those police officers to prosecute and to look into prosecuting those folks.
Ms. Freeman?
Just briefly, if you think about it, the DA in Durham County or Robeson County or some other county is not accountable to the people of this community. I am accountable to the people of this community. The people of this community elect the district attorney to make the difficult decisions. And when the evidence has been there, I have moved forward in those cases. I don't think it's appropriate in most cases for the district attorney to try and push off what their responsibility that the community has vested them with to do is.
There's no question that mental health plays a significant role in our country these days, now more than ever. With the decrease of available mental health resources and the uptick of need, particularly during the pandemic, what sort of alternatives do you propose to criminal prosecution for mental health related incidents? What resources are needed to effect these changes? Mr. Chetson?
Sure. We need to vastly expand, and I was having a conversation with some of the folks at Southlight a little while ago. We had a conversation about deferral programs and the need to expand those programs. I understand after a very long period of time that the Wake County District Attorney's Office is now offering a mental health deferral program. The problem with that mental health deferral program is that, as my opponent mentioned in a forum about 3 weeks ago, at any one time there are only 20 to 30 people who have been admitted into that program. That is far insufficient. There's a famous saying that I really like, and that is hurt people hurt people. People who are suffering and hurting, whether it is from substance abuse trauma or mental health trauma, hurt people. And unfortunately, the criminal justice system becomes the kind of bottom collecting bowl of those folks, because after other systems in our society fail, they end up in the criminal justice system. And that's a tragedy. We need to do better about funding other parts of our society that deal with mental health treatment. But one of the things we can do, or I will do as the next Wake County District Attorney, is expand the resources by partnering with outside groups, foundations, community-based groups, to bring to bear mental health treatment and to expand the numbers of folks who are permitted into our mental health deferral programs beyond the mere 20 or 30 of the thousands of people that go through the criminal justice system every month in Wake County.
Ms. Freeman, one moment, please. Mr. Chetson, you mentioned taking on this effort to partner with organizations and groups. Is Ms. Freeman not instituting such efforts at this moment?
It's insufficient. If all we have at this time in our mental health deferral program is 20 to 30 folks, people can do the math. Of the thousands of people that go through the Wake County Justice Center every month, if only 20 to 30 people are in the mental health deferral program, as was her statistic that she provided just 3 weeks ago, that is insufficient, and we need to do better.
Ms. Freeman?
I have been proud since 2014 to co-chair a group at the request of our county commissioners and county manager that is a partnership among the major hospitals, the criminal justice system, law enforcement, county and city government here in Wake County, called the Directors Group. Since Caroline Sullivan went off of the county commissioner, so over the last 3 or 4 years, I have solely chaired that group and that collaboration. It is absolutely critical that we find ways to divert away behavioral health issues out of the criminal justice system. And so what does that look like? It looks like pushing the county commissioners, which we have done successfully over the last 6 years, to significantly expand the amount of money that they spend on mental health resources. What is that translated to in our community? We have stood up a behavioral health urgent care center over on Chapin Oak Road that is not far from here. We have significantly expanded bed space at Wakebrook, and we have worked to build collaborations for aftercare programs for people coming out of hospitalization, such as Wake Med, Holly Hill, and other locations, to make sure that people have the wraparound services in the community. It also means making sure that crisis intervention training is really done extensively with our law enforcement so that when they come across a situation, they can identify, is this something that needs to go through the criminal justice system, or is this someone who really needs to go to Wakebrook or to another behavioral health system of care? And so that has happened not only over the last 6 years, but traditionally in this community through Wake NAMI, and that is an important part of that partnership. And so the very work that he's talking about doing is what I've been engaged to do. And of course, there is always more that can be done, but knowing how to pull these collaborations together, reaching those successes in increase in funding, those successes in programming, that is part of what I have a record of doing and what I hope to be able to continue to do.
Briefly, Mr. Chetson.
Yes, very briefly. And I think this gets to the issue of candor and also transparency. And I know the issue of candor has been raised this evening, and I'm going to raise it in this sense. In order for us to know how the Wake County District Attorney's Office is doing on all these fronts, we should have a transparent Wake County DA's office. I challenge you to go find the website for the Wake County District Attorney's Office that lays out in detail these programs, how they operate, the number of folks that go through those programs. You won't find that information until somebody runs for office against our current elected DA. And then you start hearing about all these programs. I challenge any citizen in this county to find the Wake County District Attorney's website. You won't find it with all of the dashboard of statistics about the resources that are going in to do all this wonderful work we're hearing about. Now, I have no doubt that Ms. Freeman is earnest and concerned about what she wants to achieve. The problem is it's almost a black box about what goes on in the Wake County District Attorney's Office because we don't have any real transparency. In addition to that transparency, you need to have accountability. When you say we're having programs, how are they working out? The only way you can figure out whether mental health deferral programs or treatment programs or substance abuse programs are working is to see how many people went through the programs, how many completed the programs, how many people ended up doing well afterwards, and what were the long-term treatment prognosis for folks. That's how any company runs its business. I requested, or my campaign requested last year, and I appreciate that my opponent is concerned about there being me talking about the win-loss record of the Wake County DA's office. But I requested last March essentially the win-loss record for trial results. And I was told at that time that the Wake County District Attorney's Office did not keep any tabulated statistics about the win-loss record at trial of its prosecutions. If it doesn't have that number, where's the number for how many people who have gone through the mental health treatment programs and how successful they've been? So I appreciate that she's very earnest about it and that she cares deeply about our community. I know that goes back generations in her family, and it's extremely admirable to see. But we need more accountability and more transparency when it comes to this issue.
Mr. Chetson, allow me to ask this follow-up question before I move to you, Ms. Freeman. Why do you quantify the justice system by way of win-loss records? Why is that the approach that you are taking and will take as district attorney if you are elected?
Sure. It's not just, and I think that's a very good question because I agree this is not a game. It's very serious. And it is not just about statistics per se, but it's about what they tell you. So I am not trying to give the impression that I just care about win-loss statistics. I care about all kinds of statistics because as anyone knows in any field, be it the law, be it finance, be it hospitals, be it nurses, be it a CNA, any of these things require you to understand what happened, what did we do, and what was the consequence. And so that's one way, maybe imperfectly, of me articulating that. But the point is that we need to know how these programs are run, who goes through these programs, and whether we are achieving the results that we want to achieve to decide whether to put more money into those programs. But it's a good question.
Ms. Freeman?
I think those people who have seen me progress from the clerk through district attorney know that I have long raised concerns about the lack of data within the criminal justice system. It is very easy to stand outside of the system without any understanding of how those systems work and what data is available and to cast stones. I think it is important that we be able to provide that information, and that is why time and time again, when there have been technology initiatives by the Administrative Office of the Courts that provides to us our technology, I have been one of those people that have raised my hand and said, let's be a pilot county. Wake County is scheduled to be the pilot county, or one of 3 pilot counties, for the new e-court system, which is going to make our court system paperless. And part of the reason why I have pushed that and put us on the front line of that is so that we will have the ability to provide better data. But this is not an issue that I have control over as district attorney. We are dependent on the Administrative Office of the Courts for our data and for access to that data. I understand that from the outside, you may not know what those limitations are. As to our program success rates, those are programs that are run by various nonprofits, whether it's Southlight or other nonprofits. They have that data. They maintain that data for the success of that program, and those are partnerships that we work with them in.
Ms. Freeman, allow me to ask a question and request a brief response. Is your office prosecuting people for charges that occurred when people were involuntarily committed?
It depends on what the situation was. Those cases are taken by a case-by-case evaluation. Unfortunately, there are times in which patients in one of these facilities assault a nurse or cause some real physical harm to someone. Those are cases that we have to evaluate as to whether we can move forward with the evidence. But generally speaking, it is our intent to divert away from the criminal justice system behavioral health issues.
It's 7:07. We need to make sure we get to questions for those who are joining us virtually.
If I could just very briefly to
Mr.
respond.
Stetson, 15 seconds.
Yes, and I appreciate that we get passionate in debates, but I am not somebody who is outside the system. I have worked inside this system for 13 years, for 12, 13 years. And so while I bring a different perspective about it, I am not outside, and I'm passionate about my work as a criminal defense attorney in Wake County. I am passionate about working with your fellow, the folks who work with you to prosecute cases, but I am not outside the system.
Ms. Meester, if we can move forward with questions from our virtual audience.
Yes, thank you very much. We do have a couple questions that have been posted in the chat. I also wanted to give the folks that are here in person the opportunity to ask questions as well. So I'm going to kind of alternate back and forth. There's only about 3 questions on the chat, so I think we've got a fair amount of flexibility to field questions that are in the room as well. If you could please start by introducing yourself. Thank you.
Hi, my name is Donna Smith. And Ms. Freeman, while I appreciate your effort to work with the various organizations and agencies in the community that deal with mental illness, it is also a fact that we simply do not have the resources to provide the services that are needed. If you have a mental health crisis tonight in Wake County, you are very likely to be unable to find a bed. And you may equally be sent out of county or even further, sometimes out of state, if you are in need. You can spend up to 30 days sitting in an emergency room in a hospital. It is also very true that law enforcement and the legal system are very likely to encounter people who are having a mental health crisis. Right now, the biggest mental health hospital in the state of North Carolina is
So an infraction case can file a motion to have their court costs waived or remitted. Court costs have gone up 400% since 2000. For the most benign offense, you can leave the court system owing hundreds of dollars. That puts you in a debt cycle, a trap that keeps you entangled in the criminal justice system. We also know 80% of the people who come in Wake County Justice Center are represented by public defenders or indigent defenders because they're too poor to be able to hire an attorney. Can we get a commitment from your office, whichever of you are elected in this role, that you will not oppose any motion seeking the waiver or remittance of court costs for a criminal defendant who's declared indigent? Because the court has already decided that these people are too poor to be able to hire an attorney. Therefore, they should be too poor to be able to pay the fees and fines that we're sucking from them. Can I get that commitment from you all tonight?
Not only can you get the commitment, but get the hallelujah. That is an extremely important component of our criminal justice system where we criminalize poverty. and we create a cycle of criminal behavior arising out of really what it means to be poor, including the RPD going around downtown Raleigh and picking up folks for homeless crimes of being homeless, essentially. We need to stop doing that. And so not only would I agree to not seek court costs and agree to waive the court costs for people who have already been declared indigent or poor by the court, but I would encourage the use of what we call non-formal deferral programs, where you aren't, because we have a very conservative legislature that seeks to always balance the budget on the backs of our the least able to afford it by imposing court costs. By having deferral programs where you say, we're just not going to charge the court costs on this case because you're going to go get the treatment. The treatment itself is expensive enough. We want to make sure you're taking care of yourself and being whole and happy for your family. I will commit to that as well, so that we are not balancing the backs, balancing the courthouse and the state budget on the backs of the people least able to keep that. One other issue about this, it's not something new, but in Charlotte, Mecklenburg, we have a DA there who is also dismissing old traffic offenses and allowing the DAs themselves to file for expungements, something that we have been very slow to do with the current DA in Wake County. So all of those things are important.
Ms. Freeman.
And I think first, I think it's important just, and I know you know this, Daryl, but for everybody to know that for a long time here in Wake County, in terms of compliance type offenses, registration, inspection, broken tail light, child seat, car seat type situations, that if you bring in proof that you have fixed it, we have dismissed those cases so that there are not court costs related to that. The legislature has taken a very harsh view of waiving court costs, requiring even that judges' names be reported if they waive court costs. We are excited that the Supreme Court has taken this position as to Rule 28 and in fact have a meeting set up tomorrow to try and build a process where we can waive those types of charges or those types of costs for people who are indigent. And so yes, Daryl, in terms of cases where someone has been found indigent, I will not oppose waiving costs or fines. Restitution, victim restitution is a different situation, but I will not oppose waiving costs or fines in those cases. You know, though, as well as I do, that a lot of times the debt that gets created really are in cases in which there is no right to counsel, right? And a lot of times it's the traffic offenses and how that snowballs and people fail to comply and then they lose their driver's license. And that is why we have recently started a mass debt relief process with the North Carolina Pro Bono Resource Center. It is important, and certainly, as Mr. Chetson says, that availability to do that has been there for a while. I would love to have the resources to keep those kinds of projects going all the time, but that is a system where we are going through for people who have not paid court debt on old traffic tickets in more than 5 years, where there is no risk to public safety, and beginning to ask that those costs be remitted so that people can get their driver's license back.
To shorten that look-back period a little bit, Lauren.
I understand.
2 years, because the evidence shows that the study that Brandon Garrett and the folks at Duke have done, the evidence shows that if you don't get the money after 24 months, you're never going to get the money. So why wait? Why make them wait an additional 3 years to qualify to get mass debt relief? Mass debt relief after 24 months, because the evidence shows you're not going to get the money anyway.
Ms. Freeman.
Yeah, I think there's always this balance, right, of trying to make sure, one, that we are not incentivizing not paying and not complying with the law versus making sure that we have in place adequate relief so that people don't get chained for the rest of their life to some debt they can't get over. At this point, where I have come down on that is the 5-year look back. That gives us almost 17,000 individual cases here in Wake County to work through. Let's get those done. Let's see how that improves the system. And then I'm always open to further conversation on these issues.
Mr. Chetson?
I agree with the 2-year look-back period. I think the evidence that Brandon Garrett has generated about that is powerful evidence, which is that after a certain period of time, and it's relatively short, 2 years, that you aren't able to get the money in any case. The second issue, there are 3 components to it. One is eliminating this issue of criminal debt and how that recriminalizes poverty and makes people forced to engage in other criminal behavior, whether it be driving while license revoked and so forth. The second issue is a mass program to restore driver's licenses. These are done in other counties. Charlotte, Mecklenburg, and Durham County have done these. Now, Ms. Freeman talked about recently, meaning last year in 2020, that she began this process of eliminating debt. Well, I mean, I first heard about it years ago, but at least going back, it became a widespread national topic after the disturbances in Ferguson. And so we've known about this issue for 8, 9, 10 years. And it goes back for people like you, Daryl, who've been working on this issue for decades. It's not a new problem. And the issue is that we have a very reactive DA's office. And when election time comes around, you start hearing about these programs and efforts to forgive the debts of poor folks, to encourage them to get their driver's license back. The last bit about that is there's currently a case before the North Carolina Supreme Court on the issue of VL status. VL status is a mechanism by which the Wake County DA's office extracts a guilty conviction from somebody who has failed to come to court in order that they can ultimately restore their license. And there'll be hearings on that and so forth, but there's no reason in the first place that that case ever should have had to gone to the Supreme Court. The Wake County DA's office does not have a very forgiving policy when it comes to license restoration. And for those of you who are fortunate enough to be wealthy enough to be able to pay off your traffic tickets, here's why it matters to you. Because when there are people who have revoked licenses to drive on the street, it's not like they don't stop taking their children to school or they stop going to work. They drive illegally. And when they drive illegally without a license, we wouldn't want to see that happen, but they don't have insurance. And it becomes a hazard for all of us. So by restoring driver's licenses, by forgiving debt, and the last bit is by ensuring that we have mass expungement relief in Wake County. We have the Charlotte Mecklenburg DA's office expunged on its own accord roughly 10,000 records when the law was passed a couple of years ago. And the Wake County DA's office has fallen far short of that. We recently had a warrant forgiveness program back in the fall, and I thought it might be as a result of the fact that I'm running for office, but the fact of the matter is only something like 43 folks had their warrants cleared up. And so it was as ineffective as being in a Wake County courthouse on a given week. We can do better. We can do better. And what I want to do is paint for you a vision of a different DA's office that takes these problems seriously and doesn't just react to them, and builds the kind of community that we all can be proud of.
Now, if I may, we have, for at least the last 5 years, worked with the Campbell Law Clinic and previously with the Public Defender's Office here to literally reinstate hundreds of people's driver's license. That is different from the Mass Relief Project. In fact, that is a lot more effective in doing that. In the Mass Release Project, you're actually clearing out records for people you don't even know where they live anymore. You're just hoping they're going to get the benefit of it because it's been more than 2 years or more than 5 years. We have consistently tried to work with Defense Counsel and with the Community Law Clinic to try and get driver's license reinstated, to try and achieve expungements, to try and give opportunities to people second chances. But, you know, we also have a responsibility to keep our community safe. And so every day it is a balancing act between those two things and trying to make sure that we are striking the right balance for our community.
If we may have the next question, please.
If I may ask one from some folks that are watching online. This is specifically pertaining to juvenile life without parole in the state of North Carolina. The North Carolina Legislative Black Caucus publicly admonished the North Carolina Conference of District Attorneys, of which DA Freeman is on the executive committee, for derailing a bipartisan bill in the General Assembly to allow people who are sentenced to life in prison for actions taken when they are juveniles to apply for parole after 25 years. The question is, what is your position on ending juvenile life without parole in North Carolina? Ms. Freeman.
So currently, under U.S. Supreme Court law, a judge has to make a determination at the time of sentencing as to whether a juvenile will be eligible for parole consideration at after 25 years or after life. I am one member of the Conference of District Attorneys, and so I cannot control ultimately what position they take on a bill. I did not believe that bill, because it included a lot of other things beyond just the life without parole provision, in terms of shortening the time frame, was the best bill to try and move that issue forward. I think the current protection under the U.S. Supreme Court case is appropriate.
Mr. Chetson?
I don't believe that the current protection under the U.S. Supreme Court case is appropriate. I think the dissent by Sonia Sotomayor was the right way to think about this, which is that when somebody commits, and these are horrific crimes, murder is always a horrific crime, but as a juvenile, we know that their brain hasn't fully developed. And she was very clear in the dissent, and I agree with that dissent. Furthermore, the Supreme Court of the United States creates the floor, not the ceiling. So that is the floor for what due process requires. But we can do better in Wake County. We are a progressive county. We care about progressive things. We care about making Wake County a better place. And one of those things is to commit to not using life without parole for juveniles. And I'll say this about my current Wake County DA. Her office, and many of you are, some of you are very much involved in the criminal justice system here, and some of you are not. And so for the people that are not, her office is extremely punitive. In 2016, her office in State v. Hodge sought a nearly decade-long sentence for a man who was a habitual felon because she sought habitual status, and for stealing a couple of video games. Now, he shouldn't have stolen the video games, but nor should he serve a decade in prison for that. And here's what the Court of Appeals said about that. They said, despite the highly irregular nature of the proceedings that occurred in Wake County and the grossly disproportionate sentence that resulted, the defendant did not receive any prejudicial procedural conduct. That's the kind of DA's office that we have. It's an extremely punitive DA's office, and it should be something that concerns us as members of what is a progressive and forward-thinking county.
Ms. Freeman?
There are a lot of facts of that case that are being omitted that I'm not going to go into tonight. Again, what we try to do on a daily basis, and what I am committed as your district attorney to doing, is trying to identify and to make sure that we are handling aggressively those cases that cause a public safety threat, whether that is through repeated criminality or through violent offenses, and to otherwise make sure that we are being fair and that we are offering opportunities for people for second chances and trying to find ways to help people be stabilized within our community. That is what I have tried to do over the last 7 years, and that is my commitment going forward.
I want to take one more in-person question, please, before we conclude for the evening.
Good evening. Dennis Gaddy is my name. I currently serve as the Executive Director of Community Success Initiative that our DA has talked about. And all we do for the last 18 years is work with people who find themselves entangled in the criminal justice system. So I'd like to address, though, the wait times that people have to do before the charges are expunged. Last year, under the Second Chance Act that was signed by our governor, we at the Second Chance Alliance were a major part of helping that come to be, and I was a part of that. And at the end of the day, with the collaboration, I guess, the work with the District Conference of DAs, the Conference of DAs, which, Laura, I think you said you sit on, we were not able to get our full request. Our request was that after 7 years, all misdemeanors that are nonviolent are expungible, and after 10 years, we wanted unlimited felonies as well. That's what we had requested, but the back and forth only allowed us to get the one felony after 10 years. Statistics say that if a person hasn't reoffended after 7 years from his last offense, he's no more likely to offend than somebody who's never committed a crime. All right? So then when we fought back to get unlimited felonies, that the comeback was we we will give you two felonies, but the second felony has to wait 20 years. So my question is, Lauren and Damon, if that is revisited, which I'm hoping it will be, is that something that you would look at to consider the wait times smaller?
Ms. Freeman?
Sure. Dennis, as you know, you and I have done a lot of work together.
And thank you, by the way.
Certainly. I do not support unlimited expungement of felonies. I don't. I think that there are a number of ways that we can make improvements to the existing expungement law. One of them is by looking at what currently is eligible. As you know, even for those felonies that are expungible after 10 years, it's a very narrow category of what can be expunged. And there are a number of offenses that I think that I would support being able to be expunged that currently are not be able to be expunged after that period of time. And there are a lot of things that after a certain period of time, and you and I may not agree on that period of time, but there are a lot of things that I, as one member of a Conference of District Attorneys, don't care about and I think would support expanding. But I do think it goes back to that issue of, striking a balance between making sure that we are not setting up a system that incentivizes in some way, conduct conduct occurring. And so, it's been a pleasure to work with expanding this. I think we can still expand it. I am not yet at a place of unlimited.
Mr. Ketchum?
For nonviolent felonies, I am at a place of unlimited expungements after the period that you've described where people have gone through a process of not committing new crimes. And the reason for that is that when people go through that period, then we know that the incentive is not there to commit new crimes. So Ms. Freeman talks about we don't want to incentivize the commission of new crimes. Well, if somebody has gone 7, 8, 9, 10 years without committing a crime, there's no reason to think that at that point, once they get everything expunged, they're suddenly going to commit new crimes. That's what the statistics show. And I think we really need to bring up to date our thinking about this, in part because we have a wonderfully growing county. We have Apple coming in. We have all kinds of businesses coming in. We want to be able to staff these with folks from our community and from all parts of our community. And we want to encourage folks to be able to reintegrate as quickly as possible. If the statistics will show that there was a fairly short time in which people did not reoffend, then I think that's proof enough. The second thing is, I think as you've discovered, and thank you so much for your work, Dennis, because it's been really transformative, that the bill that was passed also had a poison pill in it, which made it very difficult to expunge certain kinds of offenses if a felony, and you'll know more about, you're the expert on that more than me, but and Wake County has sought to enforce that fairly stringently to deny people expungements. I think we need to have a more expansive view about what is criminal justice, because criminal justice at its core is ensuring that we have a healthy and happy community and reintegrate people back into the community as quickly as possible to make them valuable parts of our community.
Folks, it is 7:37 p.m. We have reached the conclusion of our program. Madam DA, Ms. Freeman, Mr. Chetson, thank you both so much for a robust and informative debate. Folks in the audience and folks who have joined us virtually, thank you as well for joining us this evening, and it has been a pleasure to moderate this debate. I will now turn it over to Ms. Meester.
Thank you, Ms. Asante.
Thank you again for being here this evening. This will conclude our event. Thank you.
Thank you.
I don't think of you as outside.
No, that's okay. That's okay. I